where did we finish off last year? Last class. That was, we had started Polity static series, criminal justice system. We were just trying to decipher or just to acknowledge that what is wrong in the system, what is wrong which is going on. So we started off with as a part of judiciary, because justice, being seen done justice, is the most effective part of a democracy. If that is into play, like if the common citizens can see that they can avail justice, justice can be demanded, then the other parts, other structure of the organizations can work seamlessly, because justice always acts as a deterrence. Okay? So we'll just revise in like 5 minutes or so, and then we'll continue forward. So the last talk was criminal justice system. This was the sequence. See, you have to learn to push your brain to memorize things, to remember things. You just can't read it and let it go. You have to push them. So this was the whole sequence of topics which we'll do. I've written this code. C is for criminal justice system. Always there will be triple P. There are a total of 5 P's. But over here, it's first is pendency of cases, we have discussed. Then principle of justice or principles of natural justice. Third is pendency of a case is done, principles of natural justice in prisons. Today we'll also see a part of prisons. Then it's LPG, but you have to remember LPJ. Take it. Liberalization, privatization, globalization. 1991 reforms, yaad hoga just as a mnemonic. Legal, L is for legal reforms, all the legal, Bharatiya Nyaya Sanhita, IRPC, CRPC, those things. IPC, sorry, not IRPC, IPC. Then P stands for police reforms. You might have n number of committees. We'll study in detail what most of the committees suggested, what were the things that which are adhered to, and what can be done more. Smart policing. J stands for the reforms, like we discussed, the pendency of cases, the pendency of the vacancy in judiciary itself. We'll deal with all that in details. Then comes CPT. C is for the most commonly used term in the courts is contempt of court, that is C. Then P is for PIL. The PIL is a nomenclature. Worldwide, every nation has its own nomenclature for PIL, but in the whole of the world, India is the place where most of the PILs are filed. In simple, most of the cases are filed in India. And last is tribunals. Over here, this topic of judiciary as a whole will be finished, and then will come separation of powers. Okay? That is also related in DPSP also. You might be knowing separation of powers. Now, your homework was, where is the word justice or mentioned? See, it's mentioned in the preamble. Okay? Justice, social, economic or political. Remember, the preamble, the fundamental rights, DPSP and fundamental duties should be by heart. Like, not even on a fingerprints, like that it should be, because every year prelims question is guaranteed from these parts. Another fun fact is, in the whole of fundamental rights, the word of justice is nowhere mentioned. It is also a PYQ. The word justice is nowhere mentioned in the fundamental rights. Where you can relate it to is Article 32, constitutional remedies, where you can approach the courts to get justice. That. And again in DPSP, that was the homework, Article 39A, free legal aid and justice, equal justice and free legal aid. That was the part which had to be mentioned. Now, the quick revision. What was the pillars? Okay. Just, you have to make your notes in this format also. When revision, just see pillars. Try to brainstorm what were the pillars. There were 2 pillars, right? One was the government and the other was the police/legal framework. Okay. What all comes in the government? Just think what comes in the government. Judges come, the police reforms come, these comes in the government part. Okay, the judiciary comes, the whole prison infrastructure comes, and then comes the legal part. IRPC, again why I'm saying it wrong, IPC, CRPC, Bharatiya Nyaya Sanhita, even the local laws, that comes in the legal reforms. These 2 parts constitute what? The pillars of criminal judicial system. The whole of criminal judicial system is based on these 2 pillars. These 2, when they work hand in hand, justice can be delivered. I'm using the word can because presently it is like almost not delivered. Now what is the aim? Is to stop crime. Aim is to stop crime, act as a deterrence. But there are 4 points to it, as we had discussed earlier. Just think about it. What were the 4 points? First was prevention of crime, which acts as a deterrence. This is a word which is very much in news and very much highlighted whenever the word judiciary or judicial system or just justice comes. Because the whole idea of justice is to prevent anyone from doing anything. That idea is called deterrence. Second point is quick delivery of justice. That is also like Slow justice means no justice. You might have heard of this. Another point is protection of vulnerable sections, or the marginalized sections, vulnerable sections, and last, free and fair trial, also mentioned in Article 39A of DPSP. Done? That was this. Now, what is next? We are just revising for once. This was the data that was supporting that there has been a degradation of criminal judicial system. Okay? Just revise it once again. All this data has been given to you again and again. See, the foremost data, this is the two, I am assuming it's very clear. Okay, National Crime Records Bureau and National Judicial Digital Data Grid. These are the two things, official sources we have been using. Crime have been increasing by 28%. The same joke which I made last time, imagine a salary or your parent's salary or your fun part being increased to 28%. That leads to what? There is no deterrence. People are more inclined towards it. The very idea that I can go away with doing anything. I can just have whatever the means I am using and there will be no consequences. That is leading to the increase in this. And another thing, loss of value degradation, ethics, rising materialism. That's the ethics part. Whenever the society degrades, there is loss of values. That is why the society is degrading, right? 66 lakhs criminal registered in a year. You've written all this. Just revise it once again. Cybercrime has reached from 4 to 6%. There is a tremendous increase in cybercrime because like prior to this decade, there was no sense of cybercrime. There was no such thing as cybercrime. But just look at the span. Within 10 years, the amount, or if you see the data, lakhs and lakhs crores of rupees have been just vanishing from people's bank accounts due to cybercrimes. Conviction rate overall is 29%. And these are two. Conviction rate for rape is 28% according to NCRB data. What is the judicial system doing? What is the whole process? The whole process which is put in place just to give justice, and the rate of delivery of justice is 28% just because everything is simple. No deterrence. That is what NCRB data is saying. And we are also saying that, but official sources. Now see, prisons we will discuss in detail, and we've done also in prisons. There is 120% of occupancy, and in some prisons specifically there is 200%. Pathetic condition. Next, 4.4 crore cases are pending. Just memorize it. It's been increasing nowadays, but 4.4 crore is the official data we've been sticking to, and 60% of those cases are in lower courts. Okay. Last is, earlier there was 285 crimes per lakh, now it is 487. Just do the percentage. Okay. Roughly 30% increase. That is the ratio which is going, 30% increase. Now, there were two types. Okay. Justice according to Plato, what was it? Remember the code? Wisdom, temperaments, fortitude and justice. Okay. Justice simply means fairness, and when these four constitute together, again I am repeating, wisdom, temperaments, fortitude. Fortitude means courage. Courage at times of adversity, that is fortitude. And the end, it is justice. Today we will see another theory that is called John Rawls theory of justice. Okay. These two, when they combine, that is known as the epitome of justice. Next is, there were three types of justice: reformative, retributive, and the other one was distributive. Distributive, simple. Reformative, when you need to reform the society, and retributive is, again I'll just use three words, an eye for an eye. That means retributive justice. All these things should come up in your answer when you relate to it. All this should come in your answer. Now, this is a image which I thought is important to mention from ethical point of view and from judicial point of view. Okay. Now, what is the impact? See, we've seen all the data suggests what? That the criminal justice system is having a tough time, a very tough time, because of n number of reasons. But what is the impact which it has? Now you can decipher your answer in multiple parts, like impact on society, impact on individuals, impact on the government machinery and government structure, ethical impact, impact which it has on intellectuals. If you want to make your answer more precise, pinpointed, then impact on intellectuals is a different segment of it. So we won't go that much in detail, but this is the somewhat broken part of it. So what is the impact? Impact is in pendency of cases. Now it is 4.4 crore and it is keeping on rising. That is the impact. Rest, most of the impact you might, like trust on democracy deficit, brain drain, financial drain. Brain drain leads to financial drain. Okay. Now see, this was an example. I'll reiterate. This gentleman, he is a scientist and he was working in a foreign company for science, and he took the tough decision of coming home and working for India. But as you can read, due to an unfortunate incident, he lost his life. Matlab, the star jewel of science for India lost his life due to road rage or parking issue. Now what does this lead to? A ripple effect. Okay? Just remember, it leads to a ripple effect, because if you follow this news, the whole scientific community started conversing. The whole scientific community started talking about what is India safe. All the talent which they are, the sacrifices. See, science is usually not a very high paying job, if you can think of. In India especially, it's not a very high paying job. It is for the passion why scientists work, for science. But if they are willing to sacrifice money, if they are willing to sacrifice all the perks and pleasures which other professions give them, and they are working for science, and what as Indians or as the Indian government, we can't even give them a safe environment. What this led to? A debate that is India safe for scientists. What that leads to? Brain drain. We have been fighting for brain drain since colonial times, and it is happening again. That is the point. Other impacts are very general. I just want to reiterate this. Other impacts are very general. Just think of it once again, revise it. Okay? Trust in democracy will be losing. There will be increase in non-state actors. Ethical and moral dimensions. Tourism will be affected. As I said, India is known as the capital of many crimes. Okay? I don't want to mention them, but tourism is very much affected. Rest is low taxation. The investors, the high net worth individuals will think twice or think multiple times before coming to such a destination to invest their money. Okay? Everything else is about safety and security. Next, all this leads to what? Rise of non-state actors, criminalization of politics, increased role of khap panchayats. Okay? And what happens is, the whole circle is again related to deterrence. As B.R. Ambedkar ji had said, I'm trying to quote him, but I don't remember. Laws are ineffective, laws are as powerful as the people who make them. The law in its verbose, in its terminology can be very lame or can be very simple. But if the people who enforce it, their ethics are strong, their mindset is strong, they can make that simple law into ground changing nation realities. But if the laws are very good, for everything there's a clause, for everything is detailed, but the people who are enforcing it, if they are weak, then everything means nothing. That is the whole deterrence angle. The vicious circle of deterrence goes on. Okay. Next is simple. Now there were two syndromes which we had discussed. First was broken window syndrome. Okay. And this is a part which we didn't discuss last class, but it is very important for the answer. So I've mentioned it over here. See, broken window syndrome again is what? There's a broken window, and if you don't repair it within time, other people will just try to break other windows of the same building. That is the broken window syndrome. That is again leading to deterrence. If people are not seeing that criminals are being charged, criminals are being punished, they'll also do the same. That is whole the broken window syndrome reflects. Second is the credibility. As the most important part of impact is what? Credibility of judiciary is into question, which is reiterated in a Supreme Court judgment itself, Kartar Singh versus State of Punjab. Please do mention this in your answer. Who said this in Supreme Court? Kartar Singh versus State of Punjab. The court itself said that the credibility of judiciary and the whole criminal judicial system is called into question, has raised eyebrows and has got question mark, because that is the impact of this. Okay? An increased number of trials, 67% of them are under trials. These figures should be at your fingertips. You don't have to go again and again. Whenever the question comes of judiciary, 5 points always there. There are many reasons for pending of cases. Many reasons. But we'll just discuss the two. First is vacancy. Remember the two vacancies? Vacancy in judiciary itself plus vacancy in police. Okay? Remember? The UN committee reports which they said that this much should be the present, prevailing number, and what we say. Okay, not we say, what we have. For judiciary it was, think, for police it was roughly 200 something according to UN, but what we have is 144, vast difference. Same case in judiciary, we have 21, and what UN says is 50. This is the vast difference. That is a major reason of pendency of cases, because there is lack of judges, there is lack of machinery who will solve the cases and bring it in front of the judges. Both these two are pulling each other down. If the police is hota na, not they haven't got the numbers, then each case will take more time. If it will take more time, it will go to the judiciary, and if the judiciary is less in numbers, they'll again take more time. You get the circle, right? Second is there is no accountability of judiciary also. That is also, we can't speak about much about it because there's always contempt of court, but this thing is, and it has been always highlighted by the senior judges itself, that there's no accountability. Okay, rest was the finding, final notes for this. These three quotes you should remember. Okay, what were these three quotes? William Gladstone had said what? You have to write this in your answer. Had said what? Justice delayed is justice denied, as I said. And there's another, slow justice is no justice. In the same manner, justice delayed is justice denied. And second is, in state of UP versus Bapu Singh, what was said? That right of speedy trial is a fundamental right. Okay? And in the same case, this was also mentioned, that Indian courts are facing a slow motion syndrome. Slow motion syndrome is simple, as the name suggests. Everything is going slowly, and in that slow pace, you are going more slowly. That is the slow motion syndrome. And speedy trial is a fundamental right. So, this was a recap. I think it hardly took 7 to 8 minutes. Okay? But get this habit. Whenever you start the next day, when you start the next topic, just revise the old topic once. It refreshes your brain and you can start interlinking. Now, let's come to the solutions. That's what we had said. Okay? Solutions. All this was done. Hinky-dory. You understood what all the problems in the world, all the problems about judiciary, all the problems about criminal judicial system, specifically related to India. Now, what is the solutions? Now, solutions can also be magnified in many parts. Okay? Like government role, okay? Then funding, citizen role, infrastructure, vacancy issues, and police. You can, it's all given a sequence, but you can also add these subheadings, like what is the government role? What government will play to solve this issue? Funding issue, okay? Then citizen, how the role of the citizens to solve this, okay? Then infrastructure issues kya hai? Vacancy, both police, both judiciary, and the whole structure is vacant. Then a part of vacancy, what reforms that police need to speed up the criminal judicial system. Okay, now just write it down, okay, one by one. What are the solutions? Starting with, like, the most basic answer is interoperability, interoperation, synchronization between various organizations. That is a very simple answer to start with. What do we need? We need synchrony between different laws, between different wings of an organization. That, like the police, the citizens, the judiciary, all should work in tandem. That is a very simple answer. But again, first is e-courts. Okay? That comes in the role of government. E-courts. First, government will allow it, then the Supreme Court will see how it will be done. Okay? E-courts. Then LIMS, you might have heard of it, initiatives such as the LIMS. Now, what's the full form of LIMS? Okay? You should be knowing that. Legal Information Management Briefing System. Legal Information Management Briefing System. Now, that's a big word. What does it mean? It means, as you know, who is India's biggest litigator? That is the government of India itself. All the governments, state governments including, they file massive amounts of PIL. There are many stalled projects just because of this. I don't know why, but there is a होता है ना rhythm, there's a some sort of fashion in it that for everything the state files an PLI. So this organization LIMS is a repository of all the cases related to the government, like manage all court cases where Union of India is a part because it is a major litigant. ठीक है? Again the full form is, if you haven't written it down, Legal Information Management Briefing System. Other initiatives like telelaws, simple, telelaws. What does telelaw means? That everything can be known through a phone call. Nyay Mitras. Others are, the most recent is ADR, Alternative Dispute Resolutions, and we'll discuss this in detail, but in the solutions part just mentioned ADRs should also be effective and increased both ways. ठीक है? What does ADRs consist of? That is also important. Lok adalats, yeah, ADRs has to be Lok adalats, and other is NALSA, National ALSA. Okay, these two constitute Lok adalats, and NALSA is a very important topic. In fact, this ADR is a very important topic for pre and mains, because for NALSA there has been question asked in prelims exam. Okay, next is what? Fast track courts. Fast track courts are just basic courts, but the whole idea, the whole preamble or the whole fundamental idea of fast track courts is to simple fast track your cases, and it has been recommended by 14th Finance Commission also, and it has told to set up, I'm just writing it down here, fast track courts, FTC 1800 fast track courts. ठीक है? That was the idea, but it's not binding, but you know that the idea is to set up 1800 fast track courts. And the other is tribunals. See, tribunals are different from ADRs, remember that. ठीक है? Tribunals, setup of tribunals is also important. Now the whole, I need to rub all this. Okay, okay. Now the whole first is about mediation and arbitration bills. Okay. This is also very important for the idea of speeding the solution of the whole process, because most of the cases not criminal in nature. Most of the cases is what? Civil cases, money cases, family cases. Those can be resolved through mediation and arbitration. Very much highlight, like hota na family courts. What do? These things. And there's another word also. There are three words: mediation, arbitration, and conciliation. Okay? Now just remember the names. In the next few days, we'll understand each and every word and what they mean and what's the difference between them. Okay. Now, I showed a slide. In that one part was funding also. Okay? This is both. See, if you see in general, if you see the umbrella picture, that what are the problems, opposite to that is the solution. There's no infrastructure, what is the solution? Get better infrastructure. In the same way, funding is one problem also. 0.9% okay, of the GDP is being diverted towards these things. Matlab, it is not even a very small amount, but given the magnitude of problems that India is facing, it is a very small amount. So we need to increase this 0.9%. That has been suggested by various committees. Remember, whatever is the problem is the other part. The opposite of that is the solution. So if you just want to memorize the problems and you'll get to know the solutions itself. Okay, that was funding. Now, there is also has to be consensus on memorandum of procedures. Like there is so much procedural delays, there is so much of paperwork, that also needs to be memorized and that also needs to be minimized, not memorized. Like we educated people, right? But imagine a villager. Okay, I'm just taking the education part of it into consideration. That to someone who doesn't know the process, he just has to keep on running day and night just to know the next process, just to get a PIL filed, he has to run a lot. That is what memorandum of procedure needs to be simplified for the very common citizens. Okay? This whole judicial system is for what? For the common citizen. And if the common citizen is not able to avail it, for what is its purpose? Not just to serve the rich class, but to serve the common citizens itself. Okay. Now, the other was very simple. There was vacancy, number of judges. So, increase the number of judges is the solution. The other part is All India Judicial Services. That is also a separate topic. We'll do it. But one of the recommendation was to create an AIJS, All India Judicial Services, like you have All India Services for IAS, IPS, Indian Foreign Service. In the same way, All India Judicial Services. Now, others are reform in criminal laws. We have been reforming the CRPC, the IPC. For the first time I said IPC correctly. And therefore we have brought Bharatiya Nyay Sanghita. Okay. These are all topics which will deal in detail. Okay, don't panic. Just don't say what it is now. Just go with the flow. You will have each and every topic in notes perfectly. Now rest is what? Okay, reforms of criminal law is there. Then there are certain changes which needs to be specifically done to the judiciary. Okay, re-engineering of judiciary. The whole cumbersome process, or even if you see the language of judiciary, my lordship, that is the language that has been used. That is still being used. So very much re-engineering, restructuring needs to be done. Again, in the courts itself, lot of paperwork is there. Matlab, unfortunately, if you have to experience it, you will get to know. So much, there are bundles and bundles of paperwork, and everything has to be done in strict formats. For that, you will have to have a legal machinery, a financial machinery. You will have to spend so much of resources to get that. So that all this needs to be restructured. Next is, as there should be a screening of PIL, or PIL should be clubbed together or compartmentalized. That is what I am trying to say. Because for the same thing, if different people are finding different PILs and different machinery is going to work at it, so there should be a mechanism that all the PILs of the similar categories should be clubbed together, and a general notice should be passed on that for these categories, these are the available answers. Okay. Next, appointment of ad hoc and retired judges. As we are discussing, solutions related to the judiciary itself. All the retired judges and the ad hoc judges can also be appointed again, because see, we have to learn from the developed nations, or most part of the judiciary is also, or some part of judiciary, the acts has been carried forward from USA itself, like fundamental rights. Understood? So in judiciary itself, judges do not retire. So we can learn this from that. What are the best practices? In USA, the judiciary does not retire. Such intellectual people having so much there is no, given the fact we have vacancy, if there might have been a situation that no, there is no vacancy and everything is going in tandem, in an optimum, then there would have been no need of calling back a retired judges. But at today's time, we have the need, so we can call them back. This provision should be there. Okay. The CGI has itself said that National Judicial Infrastructure Authority should also be made. CGI itself has said that National Judicial Infrastructure Authority to manage what? The infrastructural aspect of judiciary. Now what happens is, see, if there is some loophole, some gaps in the infrastructure, then the judiciary advises the government to do this. But again, the whole delay string comes up. The red tapeism, the paperwork comes up. But if such an authority will be there, who will be under the direct control of judiciary itself, then things can be more faster and fast track, like fast track courts, for example. Okay. Next is, there should be new national litigation policy. Okay. This is a very detailed subject. In one line for solutions, you can write there should be a new national litigation policy. But how is it different from the older one? That is a total separate topic. You have to understand that. Okay. There should be national mission for justice delivery and legal reforms. National mission for justice delivery and legal reforms till 2026. National mission for justice delivery and legal reforms till 2026. All these are recommendations. All these are solutions which can make this whole structure better. And last year I told you 1800 fast track courts had been suggested. Okay. That this whole slide now culminates what? The whole of criminal judicial system. The end is always the solution. The way forward is always the solutions. Understood? Now, we have discussed what? Forget this for some time. This, right? J. Wisdom, temperaments, fortitude, justice. Now comes the second part. Principles of justice. Like there were triple P's. C. Criminal justice system. Then there was triple P's. Pendency of cases we've seen. Now is principles of justice. And after that will come police reforms. Okay. So, who had constituted principles of justice? His name was John Rawls. R-A-W-L-S. Okay, just remember this. John Rawls. Okay. You have to remember this name. And or if you want to remember better thing, John Rawls lies. L-I-E. ठीक है, L-I-E. John Rawls हिंदी में झूठ बोलता है. ठीक है. Now, this is the code which you have to remember. What does LIE stand for? L is for liberty, E is for equality, and I is for inequality. L is for liberty. I'll explain them just now. There's what do you need to understand liberty? Okay, it's very self-explanatory. L is for liberty, I is for inequality, and E is for equality. This is the three principles which he gave. Now, what does equality mean? Equality means equal opportunity. Okay, equality equals equal opportunity. Now, what is inequality? Inequality means equal distribution of inequality. Okay, that stands equal distribution of inequality. It means inequality is permitted only when it favors the least favored in society. It favors the least favored in society. For example, progressive taxation. As you get richer, you tax, you are taxed more, you pay tax more. That is what? When it favors the least, most vulnerable, most marginalized sections of the society, then this inequality comes into play. That is the answer. Okay, again, equal distribution of inequality. I'll just write it down. Equal distribution of inequality. Okay. Now you've got two codes regarding justice. Always remember these two. Okay. The latest one is John Rawls, झूठ बोलता है. John Rawls, lie. Okay. And the other one was, you have to remember, Plato's principles of justice. Okay. This does what? This enhances your answer. If you write such thing, if you write such political, moral thinkers, then it gives justification to your answer. It shows that you're a well-read person. It shows that whatever you're saying has been justified by moral thinkers and accepted by the whole of the moral community or the philosophical community to some extent, or the political community itself. Okay, that is the whole idea. Understood? That, see, liberty is very simple again, and equality is also very simple, but I is different. You need to remember equal distribution of inequality. When the least, the most poor people are come into play, for them, if it is done, then it is right. Okay? Now, from then on, we have been discussing what? ADRs, right? ADR. Alternative Dispute Resolution. तब से चल रहा है ADR. What is ADR? Finally, we will see what is ADR. The most important point to remember over here is that tribunals, tribunals does not come under ADR. So make a big cross and remember this. It's a trick question, it's a trap question also. Does tribunals come under? Because the whole momentum is what? To create such mechanism that this whole process is fastened up, eased up. So tribunal is also one part of that. But they know they are not, they serve the same purpose. Both of them are created to serve the same purpose, but tribunals are not part of ADR. Just remember that. Okay. Now, what is ADR? Unconventional way of settling disputes. Tribunals and the whole court structure. Remember, COURT, court structure, in which Supreme Courts come, then High Courts come, then District Courts come. This is the whole judiciary setup. This is all what? Very traditional, book by book format, but this is non-traditional. Seeing the times in which we are living, we can't just always follow the book. You have to think beyond that. That is where ADR comes in. It's a non-conventional way. It is all legal, but it is different from the legal setup. It has got its own laws, rules. This has got a very dedicated, immense, all Himalaya encompassing rules and laws, but both serve the same purpose. This is also legal, but different from the original legal judiciary. That is the very idea. Now, what are the types? As I tell, there are three words to remember. Arbitration, mediation, conciliation. We have done in the last slide. Now you will get to know the exact meaning of these three and how these three are different and how these three will help in the judicial system. Now, what does arbitration means? Arbitration is, as it sounds, a very technical term like arbitration. What it means? Agreement based. Arbitration is agreement based. Remember this. Arbitration is agreement based. Now, what it means is it's a very formal process in which an arbitrator is nominated. Now, if you just try to connect arbitration, it is agreement based. Where do we have agreements? Usually, normal people very rarely hota na get into agreement things. But in the commercial space, if you see, all the commercial, whatever the law is, but the commerce, whole of the commercial things are dedicated through this. Everything is written in contract format. That is the part which arbitration deals with. And that is why an arbitrator, who is also to somewhat, he knows the laws of the commercial space. That is when arbitrator is also appointed in this case. So you have to remember 3 A's. First is arbitrator, then is agreement, then is one separate person known as arbitrator. Okay. Most commonly used in commercial disputes. Second is mediation. Mediation stands for mediator. Okay. Its basic idea is to bring both the parties together. Hota na? He does not give a decisive role. Like this arbitrator, he has knowledge of its own. He has got domain experience and expertise. He can give his own views. His views will matter. But in the case of mediation, the sole purpose of mediator is to get both the parties or multiple parties on a talking table. Just gather everyone and bring them to talk. That is the role of mediator, nothing more. His knowledge, his expertise does not matter. And the parties are also not listening to him. Okay. Third is conciliation. Okay. See, these are all commerce topics. Okay. You don't need to go in detail. This much is sufficient for your exam perspective. If you are a commerce or finance student, okay, or if you are preparing for some other these topics related exam, then you have to go in detail. Then you'll have to make slides and you have to make different tables. But for now, this much is different, more than enough. Okay. Third is conciliation. Conciliation is informal. Okay. There is no agreement. Mediator, there is a mediating person, so no agreement required. In arbitrator, agreement required. And in conciliation also, no agreement is required. It is very informal process. And the conciliator is decided mutually. Okay. Settlement is accepted by both parties. That is, document is signed, and in conciliator, settlement is done and both parties sign. Then only it comes into effect. Basic difference. Okay. Now what are the benefits of, not these three, benefits of ADR in general. Benefits of ADR, alternative dispute resolution. What are the benefits that this beholds? First benefit is, the whole idea is what? Quick disposal of cases. No one wants to leave their busy lives and run to the courts or some dispute resolution system. So the first idea is quick and speedy disposal of cases. That is not bound by civil procedure. As we said, there was a legal system. If you go to the legal system, you have to follow strict procedure. But in this, that strict procedure is not absolutely followed. This leads to another thing. There will be less burden on the actual judiciary. If commercial disputes, family disputes go to these places, go seek resolution, seek help from ADR, then the legal judiciary, the burden, the extra burden which it was facing will come down. The present cases are already there. But the more future cases, the percentage or the increase of pendency will somehow slightly reduce. That is the idea. Now, what is next? Cost effective. As I told you, the legal machinery in India is very costly. It is, see, we all stand true to our word that we support, we respect, and we still believe in the idea of that Indian judiciary does deliver justice. But there is no hiding this fact that it is very costly. It is very cumbersome. Okay. Other is easy to enforce. Like in conciliation, we see it, if both parties decided, in conciliation, if both parties decided and agreed, then it is easy to enforce. But what happens in legal judiciary? If the district courts gave some judgment, then you will go to the higher court, then you will go to the higher court. But in this case, if both parties have agreed, then the process can be very streamlined and justice can be done. Okay, if both parties agrees, though it can be enforced. It is also very cooperative approach. See, there is no winning and there is no losing. There both are winners. In the legal system, we see I am winning, you are losing. In this, no. The idea is to find a middle way and get things done. That is the idea. So both are in a win-win situation in this case. There are no winners or losers. Both are winning. If both come to the table, talk, agree on something, both are winning, right? That is the idea. Okay. And it is more sustainable also. And on a joke part, it also eases everyone's ego also. Again, what this also helps in is EODB, ease of doing business. If all, as I said now, for commercial things, ARDR, imagine if all the commercial people went to legal system, what would happen? So much on burden, what burden the legal judiciary is having is a different thing. But all the financial contractors, all the commercial ideas, so all the businesses, if they run to them, how will the business run itself? So if it is easier resolved over here, there will be ease of doing business, and that will lead to what? More financial gains. Okay. See, now what are the issues also? Because everything has pros and cons. What were the problems? Later became the solutions. In the same way, this was the very idea with which it was brought up. Hota na? Ki the difference which this idea would create if implemented. Now, there have been some issues also. So we'll learn what the issues are. The first and foremost issue is lack of awareness. Most of them have not heard of this ADR. Okay? I don't know why it's showing up ADR. Most of them have not. The common people, होता है ना, for everything you've heard, हम कोर्ट चले जाएंगे. The new term should be, हम ADR के पास चले जाएंगे, हम mediation के पास चले जाएंगे. We'll go to arbitrator, we'll go to conciliator. That should be the new norm. Before reaching the higher judiciary, that should be the new norm. The movies have made it very famous that we'll see you in court. But the new line should be, we'll see you what? We'll see you through a mediator. We'll see you through an arbitrator. We'll see you through an conciliator. That is how the whole idea will change. That is how awareness will be increased. Okay. First is lack of awareness. Please write it down. First is lack of awareness. Second is accessibility. Like every state has its own high court. Every district has its district court. The idea of ADR has not penetrated the whole of India as of now. So there is lack of accessibility. Then finding a neutral arbitrator or conciliator. Finding a mediator is easy. Mediator is just a person. I just told you, he'll bring you together. Simple. He'll tell you, I'll bring in samosas. Please come, and you'll come. But to find a neutral arbitrator, to find a neutral conciliator is very different. There has been courses being launched for this. There have been certificates and degrees being given to arbitrators and conciliators. It is all speeding up, but at this present time, it is very difficult. And the cases which we are having, imagine the cases are in magnitude, crores of cases. Compared to that, the number of conciliators, compared to that, the number of arbitrators that we have is very tiny. That is the issue. Okay. And illiteracy among litigants. Again, I said, the very idea that half of India, see, if we're not going into percentage, like for example, 30% of India is still not that much educated, if I'm being very humble, okay. And they don't understand the legal process itself. How are they willing to understand, or how will you make them understand the ADR process? So this is a very big loophole, very big drawback, that illiteracy among litigants, whatever the judgment is, to make them understand, that is also a big complex issue as of today. Last is judicial interference. Okay? Now, what does judicial interference mean? It means that there are some high profile cases which go to these courts, but the judiciary interferes, or judiciary from time to time gives some judgments which are contradictory to what ADRs give. That leads to clashes. That leads to what? Whatever the smooth process which was going on, that becomes a halt or a pause. That is also another issue. Now, it's an issue also, but the basic difference between this and the legal system is what? You have to accept the legal order. है ना? You can always go to the higher judiciary, but at that present day, you have to accept whatever order the court has passed. That is not the case over here. It cannot pass orders. ठीक है? What happens is, it brings all the pros and cons, and that is why it has legal system passes an order, there's a winning party and there's a losing party. But in the cases of India, both are winning party. So the main idea is to find a middle ground. But if you're not willing to accept that middle ground, then what will it do? The same thing, again pendency of cases rise. Okay? So it does not have the power, like the legal system has the power, the courts have the power to pass a judgment, but ADR does not have. That is a very big issue of this. Next is, the mediators are mostly judges. Okay? So, as I said, there is no number of arbitrators, conciliators, very less. So usually, because the judges are very much more than qualified, so they become mediators. But when judges became mediators, they bring the whole legal knowledge with them. You can't separate a judge from the legal knowledge, right? So that is also sort of a difficulty, because then again that a whole legal trap comes into scene, because he is a judge at the end, right? Okay, so it is bound. Understood? Okay. Now, like we've memorized points, data, facts. In this also remember, there's one point. Just write it down. In Guru Nanak Singh versus Ratan Singh case, the court observed was that there was procedural delays in ADR. In Guru Nanak Singh versus Ratan Singh case, the court observed that there were procedural delays in ADR. Okay. Now, there's a case study also regarding Bhopal gas tragedy case study. The issue with that was the settlements were imposed on the poor. Okay. That is a very big issue. That because, see, the poor were not able to, whatever the reason might be, just understand ki they didn't have that much resources to fight a case, but the settlement, the amount was imposed on them. That was also a very big drawback. It's a proper case study. You need to understand. In Bhopal gas tragedy case study, when you see the legal angle, the judiciary was there to help the victims. Like, you can't imagine the atrocities or the pain which they went through. Nuclear thing is very bad, okay? Just very bad. And when the judiciary came into play, it should have supported, some of ease their pain, but all the whatever compensation was given to them was just pushed down on them. Okay? It was imposed, there was no mutual thing going on. Now, what are the measures taken? Okay? Just cleaning it. Okay, I don't know why it's still there. What are the measures taken? This is the last topic for today. Rejoice in relief. What are the measures taken? Okay? Again, it's not just ADR, the measures in whole. What are they taken? Lok Adalats are created. Okay? One is Lok Adalat. A very separate chapter in your polity book. Second is NALSA, Legal Services Authority. Okay? Again a separate chapter, and from both these UPSC has asked continuous questions. So very important topics. है ना? Plea bargaining. ठीक है? Plea bargaining is a very, it's not a new concept, but it is being brought to the forefront now. Plea bargaining means if you accept your crime beforehand. ठीक है? Accept crime and less punishment. ठीक है? Or plea bargaining, another meaning is out of court settlement. That is called plea bargaining. Okay, plea bargaining. It's visible, right? My handwriting is visible. Understandable to some extent. Okay. Then, other measures that were taken was Arbitration Act, Mediation Act, Conciliation Act. Okay. Arbitration Council of India is set up. What is the purpose of Arbitration Council of India? Okay. Arbitration ... Council of India. Its purpose is to make rules, make laws. Okay. Define standard operating procedures. Define the policies which will be under arbitration, conciliation, mediation. Okay. Its purpose is again what? To train professionals. We've got less number of professionals. To increase that, what we have? We've got to train professionals. Okay. Then arbitrary institutions also made. Arbitration institutions. And these are made on the direction of Supreme Court itself. Institutions. And it's, see, so just I'm writing short form. Please write it down. On the instruction of Supreme Court itself, and its purpose is to dispose of cases in 30 days. Okay, that is what the Supreme Court directed. Now, what is happening in the ground reality is a different thing, but this is what Supreme Court directed. Okay. Another thing is this whole Arbitration Council Act 2019. What it said was, कि in 12 months, domestic cases have to be resolved. In 12 months, domestic cases, and unfortunately, okay, you wrote it down. I'm clearing it. Okay. 12 months. Domestic cases resolved. Tick means resolved. But for international cases, there has been no time limit defined. No time limit. Why so? See, so it's a bad thing. But you got this. Now this is also acting as a hindrance, as a deterrence also. Because when international companies file cases and there's no time limit. Imagine if you just told, okay, your case will be resolved within a year. That will give them some hope, some scope, but there's no time and cases are being dragged and dragged. But for good things, for domestic purposes, it is 12 months and it is all being given under what? Arbitration and Conciliation Act 2019, remember that. Okay? Arbitration Council of India is also set up under Arbitration and Conciliation Act 2019. Last is Mediation Bill of 2021. Okay? What does Mediation Bill say? See, it's a bill, so we don't need to discuss it in detail. But what it says is civil or commercial cases. Okay? Just remember, civil or commercial cases, before going to the court, they can approach it. Once whatever your case may be has reached the court, then there is no need of this. But before going to the court, you can approach the mediation houses. Okay? But there's a clause that if you go to the court also and within 180 days after going to the court, then also you can come back to mediation. 180 days plus or 180 days minus. Okay? That is it. Mediation Council of India will be set up like previously we discussed. Arbitration Council, for that Mediation Council, and it will do the same things. Frame policies, frame laws, engineer them, train them, all these things. And any agreement will be binding. Like if both the parties have sat down and signed it, then it will be mandatory. It will be what? Binding in nature. Remember that. All this comes under Mediation and Mediation Bill 2021. Okay? See, that was all for today. Tomorrow we'll be taking a current affairs class, and the other is all India judicial systems. You all are judicial services. You all are preparing for some services. So we'll discuss another service, that is All India Judicial Service. Thank you. वो कर दीजिए.